an application by Geraldine Finucane for judicial review.
Yes, Sir James.
My ladies, my lords, good morning. Still on legitimate expectation, I'm afraid. And I said I was going to deliver the punchline. This was the not open-ended, not indefinite, irrespective of future events and so on, the nature of the commitment, that third aspect of the commitment. It wasn't, we submit, in the nature of a commitment that will set up a public inquiry even if 6 years have passed and irrespective of the nature of the public interest factors bearing relevantly on that question. And this was the sole disagreement with that we respectfully have on this aspect with the judgments below. It's dealt with in Mr. Justice Stevens' judgment at paragraph 160, with paragraphs 11 and 12 leading to paragraph 160, and then in the Court of Appeal's judgment between 77 and 85. And you will see from those paragraphs that even that area of disagreement is limited. They do not say, either of the courts below, that the commitment was or could reasonably have been understood to be open-ended in that sense. Their point is simply that all commitments have within them an implicit ability to change.
Could you give me the paragraph numbers of the Court of Appeal again, please?
77 to 85.
Could I register, hopefully, a mild complaint about the electronic bundle in this case? First of all, it's not synchronized with a hard copy. That always creates difficulties. Secondly, the bookmarks, and I know you're not responsible for this, Sir James, the bookmarks column is significantly deficient in that the appendices are not properly indexed. So when I, as I did this morning, wanted to locate the Corey report, which I have read, I found it extremely difficult to locate it. It's very important that we have synchronization between the hard copy and the electronic bundle, and that we have a proper bookmarks column. Yeah. Could you, perhaps, or your junior, give me an indication of the Corey report electronic numbers, please? But don't trouble now. No, take your time. Something that I just want to reflect upon.
The Corey report is in bundle 3. Sorry, appendix 2, and it starts at MS 905.
Thank you very much.
I mean, what might be convenient, my lord, I mean, I'll take on board and make sure that those behind me get on for future cases to the general points that you've made, but it may be helpful if we could produce between us a schedule of the core documents that have been referred to during the course of the appeal with their hard and MS numbering on them. Then at least you have it on a single sheet of paper.
Of course.
That's very helpful. But I'd experienced exactly the same problem that my lord was describing yesterday when I was trying to go to key documents. I think it's the appellant's business to...
Well, maybe it is, but it's a general issue.
So it's a bit unfair to be
making it to you.
Making the point to you, but you're used to that.
I've got a pretty broad back.
Well, you've acquired it over the years.
Right, but if that would be a helpful suggestion, the single sheet, that may solve a little bit of the problem.
Thank you.
But it may also be that in future cases, I don't know if it's conceivably feasible to do this, because I have similar problems in these cases.
Well, I mean, I do realise that synchronising the hard copy and the electronic bundle is not easy because of the incremental development or the organic development of these bundles, but it is of enormous assistance if it can be done. And
yes.
Certainly, as I say, I rely very heavily on the bookmarks column, and if the appendix is not indexed so the individual document can be identified, it makes it very much more difficult.
It may also be that it shouldn't be beyond the wit of man, potentially, at least to take Appendix 2 and following in all these cases and use those, as it were, so you track the hard copy numbering, because you always get the hard copy numbering months before you get the electronics. But you could start with Appendix 2 and just track those so that they're exactly the same and then move from there. But anyway, will you leave it with me and we'll see what we can do.
Beating from me, so...
My ladies, my lords, so we submit that the point that says all commitments have within them the implicit ability to change is certainly true. but the conditions as to the form of inquiry is nevertheless important, and is important as a separate and distinct feature of the doctrine of legitimate expectation. And as you are aware, it has the legal difference, which is, or the legal distinction, which is that at the stage of analysing the nature of the commitment, the burden is on the applicant, and at the stage of justification, if you push it all into that, the burden is on the state. So it is quite important, we respectfully submit, to conduct the analysis in that sequenced way. And if you do that, we respectfully submit, the right question is whether the commitment, casting one's mind forward, is apt, unequivocally and without qualification, to cover the events that have actually occurred. That's what I say about the nature of the commitment. I interpose, given the controversy yesterday as to whether or not reliance or detrimental reliance or reasonable reliance is part of the doctrine or not, I interpose at the second stage, just before coming to justification, one reference, which is that, as the learned judge records, Mr. Justice Stevens records at paragraph 171, it was common ground and accepted below that there had at least been no detrimental reliance.
Well, that's part of the reason I wanted to look at the Corey report. The undertaking was that if it was recommended by Judge Corey that there would be a public inquiry. Now, I assume that Mrs. Finucane contributed to the Corey inquiry against the background of that undertaking. Was she represented before the inquiry?
I don't know the answer to that, but my learned friend, I'm sure, will be able to insist on it.
I certainly get the impression from reading the appendix to the Corey report that Ms. Doherty and Mr. Shields were making submissions to Judge Corey. Now, I'm not suggesting that that necessarily qualifies as detriment, but it certainly goes a pretty far way, I would have thought, to explicit reliance on the undertaking, in that they were making representations to the person whose advice that the government might well achieve their aim, namely the establishment of a public inquiry.
Well, except that I'm sure my Lord is right on the facts, but
No, I mean, I freely acknowledge that I may not have got the facts right.
No, but assume you have, and I'm sure you're right on the facts, that there were representations made into the Corrie process. My respectful submission is that the outcome of that Corrie process was, in effect, a repetition by the government of exactly the same commitment that had been given before. And it's difficult, therefore, to see how that could constitute reliance if reliance is necessary. But I don't want to take up a long time on
that.
Well,
it's en passant. It's just that the
other fish to fry.
The discussion yesterday about reliance and detriment
Yeah.
sparked that inquiry.
Well, you have the reference to the learned judge's judgment anyway. Can I turn to justification and the policy reasons that existed for taking a different tack? That is dealt with, at least the facts in relation to it, and they're complex, and we do invite the courts to read both the learned judge's judgment in this respect, accurately tracing and fully and fairly tracing through the chronological sequence of events. Mr. Justice Stevens, para 166 and following, Court of Appeal effectively agreeing with him but summarising certain bits, 92 to 108. And my basic submission is that they were correct on this aspect for all of the reasons that they gave, and that their analysis of the factual situation is fair and accurate. The short points are that, firstly, a very considerable time had elapsed with all the perhaps inevitable change in the public interest factors in play by the time the decision to reconsider came about. And perhaps the fact of most significance by that stage was that there had been, by then, so we're into 2010 effectively, there had been years of protracted debate and disagreement about particularly the use of the new legislation. And the family's position pretty much throughout had been that they would not participate in any such inquiry. It's even an inquiry set up under the 2005 Act, unless there was in effect an agreement not to operate it in accordance with its own terms. And you have the appendix to the case with the relevant chronology on this aspect, page 286 in the electronic numbering. Perhaps take the basic elements of that chronology from the case itself with the greater detail in the chronology that's appended to it. But if you go to our case, if you would, and we've set out the chronology, really from, in relevant part for present purposes, between 73 and 79 of the case. And not terribly interesting, but it may be a convenient way of dealing with it. Just to trace it through by reference to those paragraph numbers, the family took issue from the outset when the inquiry's bill was published, that's 74, and the press release that was put out by them on the electronic numbering, you see that referred to in the penultimate sentence of 74, in the electronic numbering, that 766 reference is 1082. They then mounted a concerted campaign against the 2005 Act and its application to them, including writing to all serving judges, inviting them not to take up an appointment if offered. And that reference in the final sentence of 74, the 771 reference is electronic 1087. Then there was a meeting with the then Secretary of State, Peter Hayne, in February 2006. That's dealt with in paragraph 75. At which the family told Mr. Hayne that they would not participate in any inquiry set up under that Act.
Has this not been overtaken by later events?
Well, I'm going to come to those, but we respectfully...
What's its relevance at the moment?
Its relevance is that it shapes the attitude of the family, because when we come to the relevant events that my Lord is putting to me, which I suspect is the Baha Musa point, which I'm about to come to, this attitude of the family, prolonged as it is over the years, is relevant to understand what was going on then. That's why I take it very briefly, but I take it nevertheless. Then in April 2008, para 76 of the case, the family's position was that they would participate if there was an undertaking for no restriction notice. And that reference to 839 in para 76 of the case is MS 1155. And they're declining to confirm that MS reference. The 848 one is 1164. Can I come to Baha Musa? I know my Lord is impatient for me to get there.
No, I'm not actually.
Can I come to Baha Musa directly? Section 19 of the Inquiries Act is behind tab 9 of the authorities bundle, number 1, I think. MS 3195. And the first thing that we respectfully invite the court to note about it is that it's about restrictions imposed on disclosure out from the inquiry. It is not about provision to the inquiry. So there isn't any question of using section 19, and nor has there ever been, to operate it to allow anyone to hold materials back from the inquiry. And it has, through the chairman, the powers that you see on the in section 21 on page 3197. So this is about restrictions on the publication of documents that have actually been given to and are able to be taken into account by the inquiry. And the second thing you'll note about section 19 is that the statute provides that a restriction notice can be given either by way of restriction notice from the responsible minister or by a restriction order made by the chair. That's sub 2. And the statute then provides for a list of factors that need to be taken into account by either of them or both of them in sub 4. And my respectful submission is, if I need to make it, is that there's nothing inherently unfair about that. I mean, take the position which was of most concern to the family, which is that the minister issues a restriction notice. That decision to issue a restriction notice, whether in advance of or at the same time of or even after a view expressed or an order made or a decision not to make an order by the chair, whatever sequence that happens in, if the minister makes a restriction notice, that is subject to judicial review, that decision. There's nothing inimical to the rule of law about that. And it is controlled by the principles of public law, like any other decision that a minister makes pursuant to powers conferred by a statute.
Well,
including
the material that goes to the inquiry, you say, is not subject to a restriction, provided it's relevant. There's no opportunity for the minister to restrict or confine the material that the inquiry considers to be necessary.
Well, I'm not sure one has to resolve that, but on the face of section 19, it looks like that's
Well,
right.
I think it's quite an important point, but in any event, do I understand that that means that material that goes to the inquiry would be available to all of those who are represented at it?
Well, you will see from the Bahamusa Protocol when we come to it that there are steps that have been taken that were taken in that situation to work out a process by which that should occur, because it may be quite important in designing the process for there not to be disclosure to anyone, including core participants, who can cover a broad range, as you know, of material that might damage, for example, national security. But the fact of the matter is that this legislation is passed by Parliament as primary legislation, setting up alternative processes, and given that, and to the extent that it confers power on ministers to do things.
Quite, but it's just to understand what the scope of the power is. I think it's quite important for us to be aware whether the restriction notice is confined, as I think you suggested, simply to the disclosure of material received by the inquiry, or whether it has any further ambit.
Yes, you're relying on
1B.
1B, subsection 1B, to say that this is only concerned with dissemination of material which is before the inquiry out of that inquiry.
Yes, and that would include, I would respectfully submit, because it obviously would be consistent with the purpose, disclosure within the inquiry to those who are core participants.
Oh yes, I can quite understand that. But
So,
I mean, if they're going to make an effective contribution, one anticipates the argument that they've got to be privy to the documents.
well, they could be privy to the documents, or they could, and then all the usual processes for trying to open up as much as possible for gisting and all of that would cut in, and you'd have a complicated process, no doubt. But that would be managed within the inquiry.
Where do we have that?
Where do we have?
The provisions for managing the release of information within the inquiry to those with a legitimate interest in participating.
I'm not sure it's dealt with directly in section 19.
No, it isn't.
But section 19.4 specifies the circumstances, and it would presumably be said that a notice properly taking into account the factors listed in 4 would not go beyond that which was truly necessary to protect. So
That's
it may,
not, sorry, Sir James, I didn't make myself clear. It has been said, and you've just said, that you can have, in effect, a closed material procedure in these inquiries. Where do we get that from?
well, I think you get it from Section 19 with its ability to impose restrictions on the disclosure out.
But maybe it's Section 17, which is giving a general power to control the procedure of the inquiry to the chairman, so that he could say, subject to these directions that I give, it will happen in this way.
Yes. And perhaps one reads that together and consistently with 19, which says, and you can impose limitations in this way. All of the implication of that is that subject to that, the material which might otherwise be restricted has gone to the inquiry.
And been used by the inquiry in a particular way. That's what I'm getting at. It's really the follow-up to my Lord's question. Where is the source of the power? If it's only 17 and 19, well, that's fair enough. That may be broad enough. But is there, for example, a power to appoint a special advocate?
My lady, I'll have to check. I'll have to check both under the Inquiries Act and under the rules, because there may well be provision under the rules which are made pursuant to this.
Yeah, it just would be helpful to know,
Yeah.
because statements to that sort of general effect have been made, and it would be good to have chapter and verse.
They have.
Thank you.
And Section 18 is important too, isn't it? Because there's a requirement to try and secure public access subject
To any restriction.
only to Section 19. So it's not subject to, doesn't seem to be envisaged that restrictions would be imposed under Section 17. Because if the instrument for controlling is 19, but of course 19(1)A allows restrictions to be imposed on attendance that are part of an inquiry. So you could have a part of the inquiry, presumably, where the attendance is limited to some certain people.
Yeah. And I think the practice has been, and again, I don't want to give evidence, but I think the practice has been under these inquiries under this legislation, and some of the Northern Irish ones, which started under earlier legislation, were then converted into a 2005 Act inquiry, and they had exactly that sort of process. So they had, in the Rosemary Nelson hearing, for example, which was the one I had some peripheral involvement in, they would have hearings that had, even the public hearings had some time lag to check, and they had various species of hearing, from exclude everyone to include them subject to confidentiality rings. They had the gamut of procedural protections that you're familiar with. Can I show you the Bahamusa protocol? And that is behind Appendix 3, MS 122, or hard copy 906.
The MS was, sorry?
MS was 1222.
Oh,
132.
more like it.
Oh, sorry,
Yes, there was one.
You said 122, it
I did,
didn't sound right.
1222.
Thank you.
And the relevant paragraphs for present purposes are 28 and 29.
What's the date of this document?
26th of November 2008,
Thank you.
page 10, internal page 10. And so you see 28 and 29, there is, if I may respectfully say so, something of a fudge between chairman having power and minister having power. because the references you'll see in 28 to 19.2a is a reference to ministerial power. And I checked online, and the reference to 38 is to judicial reviews being brought of either a ministerial decision or a chairman decision, and it's got to be done within a particular time, I think 14 days. They put a very tight time limit on JRing those sorts of decisions. But you'll see that it's 28 at least is contemplating and rendering a decision by the chairman subject to any notice in accordance with 19.2a, which is the ministerial restriction notice provision. And then what follows in 29 is, which is why I say it's a bit of a fudge, an expectation. A beautiful compromise, it might perhaps be better described as. Inquiry expects the above procedures to be used for seeking a restriction order from the chairman rather than a restriction notice being issued under 19.2a by the relevant minister. So what seems to have occurred is something of a fudge, and the expectation being, and no doubt if it wasn't followed then Sir William Gage would have had stern words and considered his position, but the expectation being that it would go, at least in the first instance, through the processes set out in that to the chair, but nothing in that protocol, as it were, shuts out the possibility of a restriction notice by a minister, even following a decision by the chair. And of course, if he makes a decision to restrict following a decision by a chair not to make a restriction order, then one might have thought that in any judicial review that followed, the minister might be on tolerably shaky ground, given that a judicial officer conducting the inquiry had already reached a contrary view, applying the factors under 4. But at least as a matter of form, the two sit, however comfortably or uncomfortably, in tandem under that protocol. And the reason for going into all of this is because, as you're aware, towards the latter part of this process, so in February 2011, there were discussions about the Baha Musa protocol as one of 3 options that were the subject of continuing discussion with the family here. If you have appendices 3 and 4 to hand, the 3 options, I'm afraid you've got to jump a bit, but the 3 options that were presented, I think, are those set out at Appendix 4, MS 1490, hard copy 1170. And just so you cast an eye down those. So you see the 1170 is the Baha Musa one, and then the next one is a Gibson inquiry protocol that you see on MS 1491, and then one had an alternative again, which was the Hillsborough panel one, MS 1492. Those are the 3 options, and if you go back into Appendix 3, and you go to MS 1232, you will see some submissions made on behalf of the family.
Sorry, 13.
1232.
Oh, thank you.
Sorry, too many twos in play. 1232 in Appendix 3. And you'll see that those submissions state at paragraph 5 as they do. Which is in part why I answered my Lord Kerr's question as I did. So they're making their position clear under the Act, that remains. Then they refer to paragraph 29 without referring to paragraph 28, but they've obviously looked at the protocol. They refer to paragraph 29. they say in paragraph 8 on page 1233, there's no reason why a similar agreement couldn't be made. Of the three examples provided, the Bahamusa inquiry would be the most appropriate mechanism for an inquiry into the murder of Patrick Finucane. So they simply say, well, that would be the most appropriate of the three that have been presented, but they're preserving their position.
Do we have the date of these submissions?
They are, I think this is, it's not on the face of it, but I think it's pretty clear from the chronology. This is 8th of February 2011.
Thanks.
So the position is that at this stage, there is simply discussion between the family and the government. The family's view is they maintain their position that the Inquiries Act is fundamentally unsuited, but of the three options presented, that appeared to be the most suitable to them. It was not on either side of this discussion a yes, we will go ahead and participate on that basis. It was certainly not from their perspective. They were just simply asserting that that was the better of the three options as far as they could tell, but preserving the position in paragraph 5. And nor was it entirely clear that the government would have gone for that either, given the concerns that arose about national security. I can see an argument for them going for that if that was the only game in town, but there would be no yes on their side either. But nowhere did my learned friend take you in his submissions to any position, any clear position from the family, actually moving from the fundamental objection position they took to the 2005 Act. Instead, what he did was to take you to an entirely fair, as we submit it to be, summary of the family's position in those final briefing documents that were given to ministers in the summer of 2011. They were the only documents that my learned friend took you to, and those were all caveated, as you will recall. They were caveated by the family agree, or may now agree, have moved their position in relation to the 2005 Act, and they're prepared to go with it under certain conditions, was always the caveat.
Of course, the family's reaction is relevant for background, but ultimately it's the respondent's obligation, if it exists, to ensure that an Article 2 inquiry, compliant inquiry or investigation should be held. So that while, of course, the government's entitled to take into account the representations of the family, their obligations exist independently of those, don't they?
My Lord, I entirely accept that. They do, and not merely that, but in relation to the legitimate expectation argument, which is the stuff that we're dealing with at the moment,
Yep.
Objective justification is for me to establish, or justification is for me to establish to whatever standard, and the reason we're going into this is because it explains why there was six or so years of wrangling, and it also explains, because the punchline of this is not the family have agreed we can all carry on happily with the idea that the Inquiries Act 2005 will provide it, that they've accepted that the parliamentary conditions on restriction notices are all fine. And so where you end up, in truth, is a bit of a movement, but a bit of a movement which preserves their objection to the 2005 Act, selects that as the best of the three options that have been given. But it doesn't, and this comes out clearly from the briefing documents, which I'll go to in 1 second, but it doesn't indicate that the 2005 Act inquiry is not going to be subject to prolonged delay, prolonged litigation. And there was real concern at the time, proper, we respectfully submit, and well-founded in relation to the position of the family, that there would either be repeated legal challenges if a restriction notice was given by the government at any stage, or they would challenge some other aspect of the Act that they didn't like, and that the risk was that the process would then get mired with all the delays that would follow from that. And ultimately, if they didn't secure what they wanted from that process, that they would walk away from the inquiry. And now those features, therefore, fed into, they were linked to the under certain conditions point I made, but they fed into the ultimate analysis of the strengths and weaknesses of, or the strengths and weaknesses of that particular option when the government came to consider its position as it did in the summer of 2011. And if you still have Appendix 4 to hand, if you go to 1355, I should perhaps start at 1359, which was the bit my learned friend took you to. He didn't take you to a family document or correspondence making that position clear, but he took you to this, which is a part of the briefing given to Cabinet Ministers in July 2011, and you'll recall that he took you to that penultimate sentence in paragraph 4 on page 1359, under certain conditions, and that's an accurate summary, we respectfully submit, of where they are. The problem is that those conditions ultimately involved a fundamental objection to restriction notices being issued by a minister under any circumstances, with some potential softening in relation to Baha Musa. But that's the under certain conditions bit, and is an accurate statement of the family's position, I respectfully submit. And if you go back to 1355 and look at paragraph 9, you will see all sorts of concerns that arose as a result of that, and indeed of the concerns of both governmental and family kind.
Yeah, well, I can quite understand all of that, but ultimately it's for the government to conceive and decide how it's going to discharge its Article 2 obligations. And while apprehension that, as you put it, any decision may become mired in legal challenges, it doesn't mitigate, or does it, or derogate from the government reaching its own freestanding conclusion as to how the Article 2 obligations are going to be met.
Certainly so, but again, my lord, if I may say so, I'm not on Article 2.
No, I know.
At the moment I'm on common law legitimate expectation. I'm trying to build the blocks to get me to an overriding justification, and part of that does involve, so if the question to me on legitimate expectation justification is it legitimate and relevant to take those into account?
Let's forget about Article 2. I mean, if the government conceives that it has created a legitimate expectation, it's for it to decide how it's going to react to that.
I entirely agree.
Yeah, while
so some of this is a bit of a sideshow.
While the anticipation of challenges from the applicants is useful by way of background, it doesn't derogate from the government's decision as to how it's going to meet the legitimate expectation, if it exists.
It doesn't affect the government's ability to decide for itself what is a proper reaction, having taken into account the commitment.
Well, the only quarrel I have with that is the government's obligation to decide how it's going to react.
But if what is being put to me is that aspect, in other words, those matters referred to at paragraph 9 are irrelevant to justification, I respectfully disagree, because they go to how long, how costly, and whether or not the family will participate at all, and whether you can get to any outcome in that event. So they are relevant. They're just a set of factors.
Well, I didn't mean to suggest that they weren't relevant.
No.
Right.
But 2, I know I'm going to have to deal with. And 2 does raise different issues, because 2, if you're obliged to do it under 2, there's a question of principle in it.
Well, I'll stop speaking,
James,
but the only point that I make is that it's not irrelevant to the question of legitimate expectation either. But, I mean, you have my view about that, my provisional view, I should emphasise.
Well, my short submission is that those sorts of factors, including cost, likelihood of the thing being derailed and how it's all going to work and whether you're going to be subjected to repeated challenges and so on, because, or if you were to operate a procedure which Parliament has itself seen fit to lay down for these sorts of inquiries, that is a relevant and legitimate matter to be taken into account. That's a submission.
I don't think there's anything between us on that.
No. in any event, it might be thought that all the wrangling is of somewhat subsidiary importance, because what actually it led to was very considerable delay and very considerable movement in public interest and other events, including in particular in 2010 the change of government. And my submission is that it's perfectly legitimate legally and constitutionally for an incoming government to review past decisions of a previous government, and the public interest factors had moved on, and they'd done so in the way, or in the ways, which we will see recorded in the detailed briefing. So that's the first topic under justification, with a bit of a diversion into Bahamusa. Very considerable time has elapsed and so on. I wanted then just to deal with the remaining aspects of justification under three broad topics. Firstly, I do submit that a proper and the most careful and detailed consideration was given to the issue. Leading ultimately to the new decision taken in July and announced in Parliament in October 2011. The references into the judgments below, very careful analysis by Mr. Justice Stevens between 100 and 140 in his judgment, and to substantially the same effect in the Court of Appeal's judgment 41 to 61. And there were, so far as that consideration is concerned, 4 stages, as one sees from a reading of those paragraphs of the courts below. Stage 1 involved the launch of the process. This is after the coalition government has come in, there's consideration of what to do about all of this, and the Secretary of State letter on the 3rd of November 2010 launches the process. And can I invite you just briefly to turn that up so we can trace the documents through. Appendix 3, MS 1305. Hard copy 985. So MS 1305. And you'll see that the purpose of the letter is, it's a right round, it's a letter sent by the Secretary of State for Northern Ireland to the Prime Minister on the 3rd of November. And he's setting out to make him and Cabinet colleagues aware of the process that he intends to follow in taking the decision whether to hold the public inquiry into the death of Mr. Finucane. I don't invite you to read all of it. But you will see the reference to the legislation, the new legislation at the bottom of 1305 and the top of 1306. And the reason why no inquiry had yet been established, in effect. You'll see the context set out in the 2 full paragraphs on page 1306. And then over the top of the page 1307, you will see the policy that is then referred to quite often in the consideration that follows, but you'll note its nature. My learned friend's submissions focused on the second sentence of that first paragraph on 1307 to the exclusion of the important caveat in the third sentence. You'll then see the various factors that are intended to be taken into account, and they're listed at the bottom of 1307. You'll see the various costs of the other inquiries referred to at the bottom of 1308. So on notice, that's the letter to the Prime Minister. It ultimately becomes, it's formulated into a letter in somewhat similar terms about a week later, but that's the start of it, the letter to the Prime Minister from the Secretary of State. And it's that letter that is referred to in the Kieran Martin note, if you're still in Appendix 4, on the next page, 1310, at paragraph 2, you'll see reference to the Secretary of State having sent the Prime Minister a long letter setting out a sensible approach to a difficult and long-running issue, which, as he says, with, as he says, iconic resonance in Northern nationalism and so on, and explaining why it is that the process has to be followed, legally essential for the Prime Minister. The Prime Minister is told it's viewed as legally essential. And the whole of paragraph 2, we respectfully submit, is inconsistent with any suggestion of sham or predetermination, but there it is. That's the letter that's the covering memo of the day after this letter, and enclosing it and describing it as a sensible approach. Then, and the courts below dealt with this, you have the memo on which my learned friend lighted again yesterday at 1312. As I say, the courts below considered that as the high point of my learned friend's case and analysed it with some care, so I'm not going to take up much time on it. We respectfully agree with their analysis of it. And there was then, to put it in context, and so you have it, there was then a meeting between the Secretary of State, the Prime Minister, and the Attorney General, dealt with in Mr. Justice Stevens' judgment at 108, just to locate it in that. And this one is at 1320, and that occurs on the 5th of November 2010. And what ultimately happens, as you see from the first and second sentence, the first and second paragraphs in that 5th of November letter, is that the Prime Minister agrees to the course of action set out in the letter that you've just seen. I say the learned judge deals with this little sequence of events at the launch of it as the high point of my learned friend's case. He does so at 197 to 201 in the Mr. Justice Stevens' judgment, and the Court of Appeal effectively agree with that analysis of this little sequence, C 134 in their judgment, especially Roman 3. So still on the launch, on the 8th of November, judgment of Mr. Justice Stevens, para 109, there's a meeting with the family, and the letter of the 11th of November, which is in, if you go to Appendix 3, sorry to jump around, but it's just the way that these documents came out, MS 1194, hard copy 878, 1194 in the electronic in Appendix 3. And this is the letter that followed the meeting with the family. Very grateful to you and your son John for meeting with me on Monday, that was the 8th, and so on. And then you see the final bit of the second paragraph. I set out a clear process both to you and to Parliament for determining the way forward. Wants to be clear about the decision-making process you'll be following. Certainly not taken any decision at this stage as to whether to hold a public inquiry into your husband's death. Hope that I've shown that I approach this issue with an open mind. The process I've decided to follow is designed to allow you a fair opportunity to make detailed representations to me. Final paragraph on 1194. So he then invites representations within 2 months from the family on that issue. Ultimately, you don't need to do more than notice, but ultimately that period was extended by 2 months at the request of the family, I think. 1484 in the same bundle. And then you'll see that the announcement of the start of the process, reflecting all the ramifications and controversies internationally and elsewhere that would be likely to ensue, as ministers recognised. The process was announced by written ministerial statement to Parliament, as you see from the second paragraph on 1195. And then you see the list of factors on which the focus is going to be placed. And so that would enable, that focus enables them to make targeted representations to the extent they want to about the sorts of matters that are likely to feed into the decision-making process. So that's the process launched. Stage 2, I'll try and take this a bit quickly, but stage 2 is in effect the main Secretary of State briefing. There have been a series of submissions, as the judgments below record, received from government agencies and from the Northern Irish Human Rights Commission and from others. You see those who made representations recorded at in Appendix 4 at MS 1571. You see a variety of persons and bodies who made representations within the period. And then 5 months after the launch and those representations, and evidently a mass of work, with the elements of continuing consideration and the chronology summarised before you get to April in the learned judge's judgment at 113 to 117. That's Mr. Justice Stevens 113 to 117. Stage 2 is then the 1st of April 2011, detailed briefing of the Secretary of State in Appendix 4, MS 1495. And this document runs from MS 1495 all the way through to MS 1581.
Have you got the paper numbers for those ones?
Yes, I'm so sorry, my lady, I should have given them. 1175
Thank you.
to 1261. And if you want this document analysed, all the bits, highlighted bits taken out of it, see Mr. Justice Stevens' judgment 118 to 122. And it is, in a nutshell, I'll spin through it very, very briefly in a moment, but it is, in a nutshell, about as thorough and careful a briefing of a Secretary of State as I have ever seen.
And you've probably seen more than most.
And I've seen a few. As I'm sure members of the court have also. But it is a full and thorough and careful briefing, meticulous.
To many of them, Sir James, I'm sure.
Yes, no comment on that in this case. But some analysis, as you see, of the public and private interests involved, placing proper and fair emphasis on the private interests involved, including specifically the fact of the commitment having been given in the past, in 2004, that's now some 7 years ago. So there's a reference in paragraph 9 to Weston Park. There's a reference in para 10 to Corrie. You see the title on page 1501. And you see paras 11 and following for the commitment. And you see the various key quotes that then follow on 1503. And you see a reference in paragraphs 14 and 15 to the need to give due weight and consideration to the family's representations, full copies of which are attached, MS 1506, hard 1186. There's a reference, sorry, I should go back just very briefly to paragraph 4, There's a reference at 1496 in the electronic, 1176 in the hard, at para 4.
Sorry, what's the electronic again, please?
1496.
Yes. Okay.
Electronic 1176. Complex issue, recommended you discuss in detail with officials, discussion and so on. You will wish then, latter half of para 4, to consult the Prime Minister and relevant cabinet colleagues. The ministerial code stipulates, for example, that the Prime Minister must be consulted in good time about any proposal to establish a major 2005 Act inquiry. You'll see, just flicking through, if I may, just to show you the structure, it starts with the background. Previous investigations are all summarised at para 3, MS 1498, hard copy 1178. And you'll see various references, including to Stevens 3 at para 6, the DPP's consideration at para 7, then Weston Park and Corrie, previous government commitments, just going on the titles, and then we get to the representations, and then we get to the public interest test at 1507, 1187 in the hard, setting out the various factors, and then setting out what the submission then does, the briefing then does at paragraph 17 on 1507. And how to approach those matters in paragraph 18, including, see the pre-penultimate line, explicitly taking into account the factor relating to the previous commitment made. And then you see the title on the top of page 1508, 1188 in the hard copy. Various reference to the politics of things, including in relation to the relationships with America and with Ireland in the light of the Weston Park Agreement at paragraphs 21, 22 and 23. And obviously the position in relation to Northern Ireland and the politics there. Then an analysis of the, so effectively what is being done is to take the bullets in paragraph 16, as you see, on page 1507, 1187 in the hard, and then to analyse them by number. So the first of them is 1508, the second of them starts at 1510 in the electronic, 1190 in the hard. And then there's an analysis of public interest factors in favour of an inquiry and public interest factors against an inquiry in relation to each of those heads. So that's the structure. They take the public interest factors and they analyse for and against under each of them, including therefore going through the titles 1516, experience of other inquiries established after the Weston Park commitments. So a detailed analysis in relation to those, including in relation to the cost of them, as one sees at paragraph 42, 1517. Then Title 4, 1519 is the delay that has occurred since the 2004 announcement and the potential length and so on. Political developments is Title 5, 1521, electronic 1201 and hard. And then costs are analysed as the sixth topic at 1524. But it is quite important to see where these sets of analyses actually lead, because the structure of this document is to analyse it in that balanced way. And then that feeds into a variety of different policy options, which are in essence going to be the menu from which ministers will ultimately select. And policy options is therefore the next major title at 1527 in the electronic, 1207 in the hard. You'll see the bold and capital title policy options. So that follows the bold capital underlined public interest test section, which started at 1507. Now we're on to the policy options. Where does all that public interest analysis feed? And here are the policy options, here are the things that need to be thought about in terms of actual delivery. And you see that there are a variety of policy options identified. And the summary of the potential model, so 2005 Act inquiry is the starting one, option A at 1528. And then you'll see what is then done is to summarise the nature of the beast, and then to try and pull together some of the public interest factors in relation to that particular option. And if you look, for example, at the star on page 1530 in the electronic, 1210 in the hard, you will see the discussion of the Bahamusa disclosure protocol, which we talked about earlier. And you'll see in particular the final two sentences of that starred bit referring to Bahamusa on 1530. Then they considered limited 2005 Act inquiry, starting on 1531 or 1211 in the hard. Then full non-statutory inquiry. And then, perhaps most relevantly to note, 1537 or 1217 in the hard. And this is, in essence, what became De Silva. Non-statutory review and information recovery is the title on 1537. You'll see the summary of the various key features of this model. And you'll see, again, the various analysis against the public interest factors that then follows. So perhaps that's the key one to focus on, at least for present purposes. Then lots of blanked out pages, no doubt for LBP purposes. Even the title at 1544, Electronic Judicial Review. Well, there's certainly been some judicial review. Quite a lot of analysis of that judicial review, which is behind closed doors. And then various annexes to finish off the document. Including in particular quite an extensive analysis of the Stevens overview summary on MS 1565, hard copy 1245, and similarly of the Corrie report, starting at 1567 or 1247 in the hard. And then a summary of the representations received. You'll recall this was the page I took you to earlier on to show the representations, the identity of those who'd made representations. But this document includes a summary of their position at page 1571 in the electronic, 1251 in the hard and following. Quite a full summary of the submissions that were then made. So that is the core Secretary of State briefing with the analysis of what ultimately became De Silva, as we've seen, full-blown analysis of the public interest factors, a fair taking into account of all the representations that have been made, and as I say, a very full analysis for the Secretary of State, and it's quite important to recognise, given a point which I'm going to come to about you can't tell what the reasons were. And normally in relation to ministerial submissions you have an analysis of the issues and then a recommended set of options from civil servants, and quite often you simply get the chop of the minister put on it, a signature saying approved or agreed or recommendation A. But here one's got, as I say, a full-blown analysis of public interest factors feeding into the various options. So the idea that one should, as it were, ignore as reasons to be excluded some of the features that led to or analysed under, in particular, what became the De Silva option here, as hopefully submit, is untenable. But this document also indicates, in the various paragraphs I took you to, that the nature of the issues, the concern about international and national reaction and so on. So all of that is unsurprisingly being managed, and this is at the top of the tree. This is right at the top of government. This is Secretary of State briefing in the knowledge that the Prime Minister is going to have to be consulted under the ministerial code. So that's stage 2 of the process. Stage 3...
Can I just clarify? Clearly there are references here to Article 2 and the need to take that into account. And we don't, of course, have any legal advice as to whether any of these procedures did comply with Article 2. But we do know that page 1232 to 3 of the hard copy, that there was anticipation of a potential conflict before the Committee of Ministers on that issue.
Yes.
But
I can't remember quite what stage we reached. I think they'd done the...
Page...
There's reference, yes.
1233,
yeah.
They refer to the fact that the committee didn't actually require an inquiry, but anticipate there may be a reopening of that.
Yeah.
But as to what view was taken as whether any of these procedures did comply with Article 2, we have to rely on your submission.
Yes, and in fairness, it was and perhaps remains to some extent quite a difficult set of issues, because we were still in the throes here of Magochi and Macaire and all of that debate to which I will come. Stage 3 then, narrowing some and exploring other options, having considered that briefing, and one has as the next document after this was the 1st of April, you'll recall, and if you go to MS 1582 in the same appendix 1262 in the hard, you'll see an email from the private secretary to the author of that briefing, Mr. Threlfall.
I'm sorry, what was the...
1582.
Thank you.
And you'll see that what happened, paragraph 1 of that document, was that there had been a very full oral briefing and discussion with the Secretary of State. And the Secretary of State's approach and views are set out at paragraph 2. And there are various provisional views that are reached by the Secretary of State at that stage. And those ultimately change following entirely proper discussion with the Prime Minister, it appears, but there's nothing sinister or improper about that. It simply indicates that these decisions are difficult, and after discussion with colleagues, it's perfectly appropriate to change or to focus on a different thing. But that's April and the Secretary of State's process, as it were, up to that point. There was then a meeting on the 6th of May 2011, see Mr. Justice Stevens' judgment, para 125 for this purpose, and that's at 1594, or a record of that is at 1594, 6th of May 2011, 1274 in the hard copy.
Sorry, what was the electronic again?
1594, my lord.
1594, thank you.
The meeting was on the 5th of May, I think.
The meeting was on yesterday, exactly so. I'm sorry, my lady. Yep, 5th of May. Yep. And then you'll see the third paragraph in particular. And as it were, this isn't some thunderbolt out of the blue. This is, in essence, the option that we saw extensively analysed in the Secretary of State briefing, the one that became the De Silva review, whatever it was, option C or option D. But then further work is done on that at the request of the Prime Minister, and that's worked up into a slightly more detailed option. So this is in effect taking forward the option that we saw earlier in the full briefing. It was option D on page 1537, as you will recall, but this effectively develops that. And the relevant page for this development at the request of the Prime Minister is at 1597 in the electronic and 1277 in the hard. And the detail of it is at Annex A, the detail on the potential model 1600, electronic 1280 in the hard. So that's the position in May. Then the further chronology, taking one up to stage 4, is set out in the learned judge's judgment at 128 to 136. And ultimately, there is a meeting of Cabinet Ministers on the 11th of July 2011. And there is briefing for the purpose of that decision-making meeting, both of the Secretary of State and of Cabinet colleagues. So the briefing for the Secretary of State on the 8th of July 2011 is in Appendix 4, MS 1618. And this is again from Mr. Threlfall, so he knows that the Secretary of State's already had the full April briefing, the May development pursuant to the discussion of the Prime Minister, and now, as it were, given that he thinks he might be chairing the meeting, or that he might be asked to outline the views with the Prime Minister chairing, he's setting out key points, as it were, for introducing matters to those who are around the Cabinet table, effectively.
Well, it's not the full Cabinet, is it?
It's not the full Cabinet, it's
2, 3, 4, 5, 6.
a selection of. But you see, given, I ought to perhaps point out that given my learned friend's criticisms of yesterday, at 1620 he launched a criticism and said, well, there wasn't proper thought being given to any of this. But you will see that these points are all being developed. The ones on page 1620 in the electronic, 1300 in the hard, they're all being developed in answer to the question which of the three options that are identified at 1619 or 1299 in the hard is the best one. So it's now narrowed, as it were, to 3, and all of these points are going so it's either full-blown 2005 or it's nothing, first and third bullets, or it's the intermediate position. And then all the points that are made there follow. But of course the Secretary of State's had access to all of that earlier briefing. And the briefing by Cabinet Office, also of the 8th of July, is at 1353 in Appendix 4. So I'm afraid you have to go back, even though in time we're about the same place.
Right, what's the
1353 electronic, 1033 in the hard. 1353?
well, it's not the beginning of a document.
It isn't. I was about to explain that, or try to.
I've gone to the page before, so it tells me.
Yes, but what you'll need to read, as it were, together are that document and 1358, or 1038 in the hard, 1358, detailed background paper. And also the briefing to the Prime Minister, which is referred to at 1374.
And we can see that the very detailed submission was also going to be available at the meeting, because
Yes.
it's mentioned in paragraph 21 of the briefing paper.
Yes. But in essence, I'm not going to have time to go through all of this now, but if I could invite you at some point, if you're going to flick through, as it were, the key documents that briefed, it is really one of the Secretary to the Secretary of State in April, and it is these documents, but in particular the detailed background paper and the paper that precedes it at 1353. And again, without taking up too much time on this, if I can invite you just to go to 1355. You've already seen paragraph 9 of this because we went to it earlier on. 1355 or 1035 in the hard. But you'll see the options, the key options identified at paragraph 8. And then the detailed background paper, if one flicks forward to that, an analysis of the positions of key players. Again, going to the nature of the decision at 1359. 1359 in the electronic, 1039 in the hard. Then an analysis of the public interest factors at 1361 and following. An analysis of the 2005 Act Inquiry's route, 1362. And then you see in particular, and this is perhaps relevant because it's what the decision ultimately became, the analysis at 1364 or 1044 in the hard, just below the hole punch, well, you haven't got a hole punch, but it's a third of the way down the page. If ministers conclude that it's not in the public interest to proceed with an inquiry and wish to pursue an alternative route, bang, and there it is. That's the analysis, in effect, of De Silva at this level. And then Annex A will now be familiar, because this is in effect, the worked up version that we saw earlier with a bit of minor and irrelevant alteration, but Annex A at 1368 or 1048 in the hard is what became De Silva. And then, as I say, the specific briefing to the Prime Minister at 1374 or 1054 in the hard. Yes. And 1361, just to note, sorry to jump around back into the detailed background paper. You will see that there's a reference back, and there will be available, as it were, in effect, the April briefing. So I think that might make this point. 1361 or 1041 in the hard.
That's paragraph 21, is it?
That's paragraph 21, exactly. And then just to show you the final part of this decision made, one's got 14th of July, the one my learned friend took you to yesterday, a letter from the Prime Minister's office to the Secretary of State at private secretary level. That's Appendix 4, 1382 in the electronic, 1062 in the hard. And again, I'm not going to go back over the detail of that, but you see all of that. And then, and again, I'm sure you picked it up from the judgments already, but the reasons for going down the route that they did were then set out in the statement made and in the debate that followed in Parliament. Dealt with in Mr. Justice Stevens' judgment at 139, and you find that statement and that debate in Appendix 4, electronic 1649. So the Secretary of State for Northern Ireland announces it, and there's then a debate. And perhaps just to save you having to read all of it, may just be worth putting a sideline down the two paragraphs in the middle of them, just below on page 1649, electronic, or 1329 in the hard, where you'll see a record of the Prime Ministerial apology and the acceptance of the conclusions reached and so on, so that paragraph. Setting out who Sir Desmond is and what his terms of reference are going to be at the bottom of the page and over onto the next page, 1650, making the point about a third of the way down that page in the paragraph beginning, I have agreed the terms of reference, that Sir Desmond is being given unrestricted access to all of the documents in effect and will be free to meet any individuals who will assist him in his task, open to him to invite or consider submissions as he sees fit, full support and cooperation of all government departments and agencies in carrying out its work. And then perhaps the rest of that page and over onto the first full paragraph on the page after 1651. And then perhaps one other bit on page 1654, the first two paragraphs on 1654 or 1334 in the hard. So in a nutshell, in relation to the process, therefore, we submit fullest and most careful consideration, opportunity for representations taken by the family along with meetings and taken into account, factors likely to be of importance identified at the outset, process announced in Parliament and then followed, process involving consideration and ministerial decision-making at the highest possible level, and the nature of the decision evident from the analysis that you've seen. So that's the first of the broad themes, process. The second of the broad themes is entirely sufficient reasons, as we submit, for reaching the different view that they did in 2011. they took into account, as I've already indicated, the fact, as you've seen, that the commitment was in fact made. And in that respect, Mr. Justice Stevens at 184 is entirely correct. But the public interests involved were complex and multifaceted. They were analysed fairly in all of those briefings. And the reasons that emerge from a fair reading of that process picture that I've just taken you through at breakneck speed, but that was analysed much more carefully by Mr. Justice Stevens and the Court of Appeal, the core reasons emerging are in effect speed. There had already been significant delay and a desire to, in the public interest, to bring matters to a conclusion if possible, as it was put by the Secretary of State to Parliament, MS 1653, final para, an opportunity to move the argument on in the context of the troubles and the developments. And as he put it at MS 1650, the public should not be kept waiting many more years for the truth to be revealed, and perhaps encapsulating the balances involved in the decision, the quickest and most effective way of getting to the truth. So speed was obviously a critical feature. The backdrop was an acceptance of and an apology for the basic and core element that there had been collusion, a prime ministerial apology repeated in Parliament by the Secretary of State, and an acceptance of the clear statements made in Stevens 3 in effect and Corrie. Cost at a time of real financial crisis, also important, a proper consideration we respectfully submit. And so far as that is concerned, there was indeed a general policy that the coalition had, entirely properly, about open-ended and costly inquiries, as it's put. There's nothing wrong with that. It's entirely lawful to have a policy which is based on real concerns about the cost and perpetual prolongation of these sorts of issues and the inquiries that follow. You saw the sort of numbers that were involved in the other inquiries, and the history indicates that those risks are real. But of course, and critically, which is why I drew attention to that bit in the ministerial letter, the Secretary of State letter right at the very beginning, that policy itself was not absolute, as my learned friend's submissions appeared to suggest, but it was subject to the rider that each case would be considered on its own merits. Again, entirely properly, and that was precisely what happened. And then that the review process that they were proposing to set up was, in their judgment, likely to be an effective and satisfactory way of getting at the truth more swiftly and of opening up as much as could be opened up to public gaze more swiftly. On opening up, as the Secretary of State said to Parliament, MS 1649, there would be a further process, quote, to ensure that the truth is revealed. And on its effectiveness, I'll come back to that in a moment, but my submission is that this is properly to be considered an effective process, conducted by a distinguished and independent person. So ultimately what happens is that the advantages are weighed of this type of process versus the potential disadvantages of not having a full-blown 2005 Act inquiry. Into the mix go the broader issues, the peace process, the position of the government in Ireland, the position of the Americans, the position domestically in terms of Northern Irish politics. Into the mix go the private interests and the fact that the commitment had been given. Specific consideration given to that, and if you want that confirmed, Court of Appeal judgment 109 to 115, agreeing with Mr. Justice Stevens 167 to 168. What then of the suggestion that there is no ministerial statement, or that you can't tell what the reasons were? my short submission in relation to that is that that was exactly the point that my learned friend ran before the Court of Appeal and that was squarely rejected as untenable in their judgment between paragraphs 90 and 108. And here one has perhaps 2 points only to mention. Firstly, one has the Prime Ministerial letter of the 14th of July 2011 that you've seen, which contains all of the themes of reasoning that I've just summarised, and you have the statement made by, or the statements made by the Secretary of State when announcing the decision in Parliament. So you have there quite sufficient record of the essential reasoning. But in any event, and more broadly, I should make this point because it's an important point to how government, relating to how government more generally functions. I do respectfully submit that it is entirely appropriate in this sort of case, and indeed other cases involving ministerial decision-making, to have regard to the briefings as themselves contributing to the elucidation of the reasoning behind the minister's decision. Sometimes that may be more difficult than others, but it is easier, I submit, in a context such as this, where one has full-blown analysis of the for and against position in relation to the various policy options, and then one of those policy options is plumped for, as it were. So all of the public interest analysis feeds into that selection. That was one of the core points made by the Court of Appeal in this case, and that is a legitimate basis for government to rely upon the nature and detail of that briefing, both in relation to the options that are rejected and in relation to the options that are selected. So I do submit that those, particularly those 2 core briefings I mentioned, the April 2011 one for Secretary of State and the July Cabinet Office briefing for ministers who were taking part in that meeting, those are the critical briefings, and one can discern all the reasons that ultimately fed into the summary form and the things that go into announcements in Parliament and all of that. But all of those themes, all of that reasoning is consistent and part of a piece.
If we want to know what the Secretary of State himself thought about it, we presumably look to his statement to Parliament.
You look to the statement to Parliament, and ultimately this was a collective decision of sorts. Wasn't a full-blown...
Yes, but the point was being made that Mr. Patterson should have given evidence personally in the judicial review proceedings. But I suppose the alternative here is he's given his statement to Parliament.
He's given his statement to Parliament, and moreover, as I say, this was not just the Secretary of State's decision. This was a decision taken by all the ministers who participated in it, including the Prime Minister. And I do respectfully urge the Court against, as it were, any conclusion that you need in this sort of case, or more generally, ministerial evidence in judicial reviews. That has never been the practice, at least in England and Wales. Those reasons are always given by civil servants, often nowadays exhibiting the final ministerial submission or briefing. And the reason that is satisfactory inter alia is because, as we all know, the government is subject to the duty of candour, and that involves playing the judicial review game with its cards face up, as it was memorably put, I think by Lord Justice Laws in an earlier decision. But there is nothing wrong with that. We've dealt, if you want, the submissions we make on that specific issue, and again, we hadn't understood it until my learned friend made his oral submissions to be part and parcel of his essential argument, or rather more seeking general guidance from the court. But we've dealt with that in our case, and I'm not going to go back to it, that question whether you need a ministerial statement. That's the second raft. The third and a final raft, and I'm going to take this in one go, and it's relevant both to legitimate expectation and to Article 2, to make that clear, but I haven't quite got to Article 2 yet, but I'm going to take this in one go. The third raft in relation to legitimate expectation was that the decision wasn't to do nothing, That was one of the options on the table. It was to acknowledge and apologise for collusion and to appoint Sir Desmond de Silva. And we do respectfully agree with and invite the court to agree with Mr Justice Stevens at 185 in that respect. He analysed, Mr Justice Stevens contains the most extensive analysis in the judgments below of the de Silva process, and his conclusions, he deals with that at 88 to 99 of his judgment below. That's where he deals with the facts so far as de Silva is concerned. And it is perhaps just worth taking up the Desmond report. It's in, for relevant part, it's in volume 5, appendix 5, and that appendix starts with some pretty desultory correspondence, and then the report begins at MS 1704 is the first part of volume 1. And the structure is that you've got volume 1 in paragraph, sorry, volume 1 in appendix 5 and volume 2 in appendix 6. But my short submissions before just touching on a couple of points of detail, and I'm going to go, you'll be pleased to hear, only mercifully to the executive summary and the chapter 1 which deals with process, because those are the relevant key bits. But the short submissions in relation to the de Silva review and report are that it was a very substantial and independent review leading to a very substantial and detailed report with a great deal of information placed in the public domain, with access to lots of documentation, not just or not simply the material that was before Corrie, but including Stevens 3 material and including new material that he called for from the government agencies that you saw referred to in the Secretary of State's statement to Parliament, and drawing on interviews that he had conducted himself. And I may say, taking a properly broad view of his remit. And it resulted in this report being published in a pretty speedy timescale. So that balance between speed and cost and effectiveness did lead to this being produced. It's dated the place before Parliament, I think, on the 12th of December 2012. And you'll recall the decision-making to set it up was announced in October 2011, so just over a year to produce this. Just go to Appendix 5, if you would, for the moment. And I promise I'm not going to go through all of this, but you will see, perhaps if I could invite you at some stage, at least just to flick, and I'll pick up some bits as I go, but just the bit really to read, I respectfully submit, is the executive summary and principal conclusions.
Yes, you asked us, I think, in your written case to do just that. I'm
very grateful. Then can I take that as done? 1711 is where that starts, and 1732 is where it finishes. That's electronic numbering, and 1390 and hard, and 1412, or to 1412. You may have, my version certainly has inconveniently no paragraph numbers on some of these pages, but electronic 1712 is quite a good summary of the nature of his work. So 1712 or 1391 in the hard, really paragraphs 5, top of that page, over to paragraph 12 on the next page, summarises core points about the process. And then if I take that as read and go into just into the body, the background to this review on page 1733, hard copy.
Just one query. When I read this, I saw in hard copy 1390 is page 3 of the report, which goes up to paragraph 4. 391 is something else, and then 393. The next page we've got is 393, and I think that's true in hard copy as well as soft copy. So we're missing paragraphs 5 to 10.
Well, is your hard copy 1391, does that start the work of the independent review?
Yes.
Well, my lord, I think what's happened...
Oh, those are the paragraphs which haven't been...
I'm afraid. If you write
numbers
if you write 5, 6, 7, 8, 9, 10...
That actually works, does it?
And it works.
Works.
Yeah.
I know it works because I did it.
Yep.
Okay.
But I'm sorry for the inconvenience of that, but yes.
I was just scared I might have missed something. Thank you.
No, but those, which is quite boring that they're the ones that don't have them because they're quite important.
Yeah, I was also confused because we went from 1391 to 1393, and I wonder if those are missing 1392. That's what caused me to be suspicious. But it read okay. But
yes, that I can't explain. there is a ghost page.
Yeah.
The paragraph numbers work if that.
It seemed to read
Yes.
okay, but I was just wondering if I missed something. Thank you very much.
And what you were missing were the essential paragraph numbers. So if I go on to 1733 in the electronic 1413, background to this review, and just pick up some points in relation to process, you see the terms of reference.
Sorry, will you say that electronic number again?
1733.
1733. Right.
Should be 1413 in the hard. Is that headed background to this review?
Yes.
Yes.
Terms of reference at paragraph 1.4. So speed's built into it. He's requested to produce a full public account of any involvement and so on, and makes clear in the very terms of reference that he's going to have full access both to the Stevens archive and to all of the government papers, including from the named organisations. And you will see that he considered it appropriate to explain how he was going to approach his terms of reference at paragraph 111 to 114, MS 1734 and to 1735. He then comes at the definition of collusion, just to go show you the structure of it and the titles. It comes at the definition of collusion under 115 and following. And then he sets out at some length, and again you've got missing paragraph numbers, but this time rather more extensively, which is even more boring. But it sets out the methodology at 1739 in the electronic, 1419 in the hard, from 1.31 onwards. And so what he's done, and again, if you want to read a little section, that's probably the key. Those 3 or 4 pages running from 1739 in the electronic to just above the title anonymity on 1744, because that sets out how he went about the process, what documents he looked at, that it was inquisitorial, that it wasn't simply a Corrie 2 review of the papers or a rerun of Stevens. It was a far more wide-ranging process. He took, as he put it, a fresh look at all the evidence, and he re-examined it all. He did so having access to the Stevens archive, having access to all the papers that he considered he wanted to see, in all of the departments you saw mentions in the terms of reference. He examined the mass of information collated over the years by the criminal investigations. But his approach, if you just go back to the executive summary, was as set out in para 7 of that on, if you put the manuscript numbers in, third full paragraph from MS 1712. And you see the volume of material and the nature of the documentation, just to focus on that for a moment, from MS 1739, paras 133 and 134. And there's nothing to indicate that he didn't have access to everything. Indeed, as he acknowledges, and it may be your paragraph numbers run out here, but on 1740, the second paragraph on that page, that's in fact 1.36. Important to acknowledge that I have received full and unequivocal cooperation of all relevant government departments and agencies in carrying out my work. Although I had no statutory powers of compulsion, I was given access to all the evidence that I sought, including highly sensitive intelligence files, and so on. Therefore, he had the advantage, see the next paragraph, which is 1.37, of seeing and analysing a significant amount of material that was not available to Sir John Stevens and Justice Corrie. Through a flood of lights on certain events that are crucial to my findings, I've had to re-evaluate the evidence they previously scrutinised, on occasion testing the witness statements produced, and so on. And he then deals over on the next page at 1741 with oral evidence and written submissions, but oral evidence. And he specifically notes in the first paragraph under that title, which should be 1.44, but the paragraph number may be lost, on 1741, under the title Oral Evidence and Written Submissions, although the government established this review as a document-based process, I decided it was necessary to interview key individuals in order to fulfil my remit.
But would I not be right in saying that in the discussions prior to the appointment of De Silva, it had been envisaged that he would interview people, and that there's an oddity that it's not within the formal terms of reference? But it clearly was flagged up as something that was going to happen.
My Lord, I think you're right. Yes. And it is perhaps an oddity that it wasn't in the terms of reference, but mostly it's made no difference because he's taken a sensible view to how
it did strike me
as an oddity.
Odd that this was being said, because I did see among the papers clear references to the fact that he would interview people.
Yes, my Lord, that's fair and correct, but as I respectfully submit, it's important that he did it.
Yes.
And there's nothing to indicate that he didn't see those that he wanted to see. The list of the witnesses he spoke to is on the facing page, the next page, 1742. You'll see in the second full paragraph on the page, oral evidence was received from the following. That should be 1.48 as a paragraph number. And you'll see the reference between the two lots of bullets. Also sought to meet one of Brian Nelson's former handlers, A13, though in the event this was not possible due to medical reasons pertaining to the handler. And he noted, if you go to the next page, 1743, second full paragraph on the page, I should also note that the passage of time has meant that my review was deprived of potentially important evidence because documents have been destroyed or witnesses have died since the events in question. And of course, as time moves on, the ability to get a full picture diminishes for obvious reasons, and that was one of the concerns that Strasbourg had in the Finucane case at paragraph 89 of their judgment, which we'll come back to. But you note what is said about those who are now sadly deceased, paragraph 1.50, which is the second full paragraph on MS 1743 or 1423 in the hard. So that is the nature of the process, and I hope that gives at least a flavour. 3 specific points perhaps to note about the process. The first is that in assessing compliance with Article 2 when we get there, and all the relevance of this strand for the purpose of justification under legitimate expectation, we do submit that adversarial process has no monopoly. That is obviously so, given that many systems within the Council of Europe, even court processes, are inquisitorial in nature. And there's no, in principle, requirement under Article 2 even for there to be cross-examination of those who are representing those with an interest in the inquiry. So far as this process, that's the first point. The second point is that the Finucane family chose, as is their right, not to participate in this process. And that I described as, I hope, not unfairly, as slightly desultory correspondence, but you get a flavour of that if you go to MS 1689. Perhaps the letter from Madden and Finucane starting at 1688 to Sir Desmond immediately after his appointment. And you'll see from the earlier correspondence that in essence he'd written to them seeking a meeting and inviting them to participate. And this was the response. And you will note, just to get a flavour of that response, the 15 questions that were posed to Sir Desmond, bottom of 1689 or 1368 in the hard, to MS 1690. As I say, it's their right not to participate, but it might be thought that it would have been possible to participate and to reserve whatever rights they wanted to reserve about the adequacy of the process, but that wasn't a course that they chose to take. The third point is that the yardstick, and I'll come back to this when I deal with Article 2, of any such review or inquiry is its effectiveness. I'm going to come back to Lord Roger in L for that purpose. But my submission, in short, is that it plainly was that, conducted in the manner that we've seen by an independent person, examining issues going directly to accountability and going directly to systemic issues also, including, for example, the adequacy or lack of it, in Sir Desmond's view, of the framework for agent handling. See the executive summary, powers 21 to 26 on that point. MS 1714. So that was the process. The report and the outcome, it was published in December 2012, so just over a year. It was published.
Can I just ask a question about that? I've seen a reference to transcripts of the oral interviews. You can find one on page 1772, electronic 1452 paper. Transcript of meeting with A/05, footnote 12.
Sorry, I'm missing that. 1722?
1772.
1772, I'm so sorry.
Maybe my fault. Footnote 12.
Yeah.
Transcript of meeting, and he quotes from it. I wondered, were the transcripts of the meetings made public?
That I don't know, and I'll have to check. Can I check that over the short adjournment and give you an answer? So it's published in December 2002, both the findings that he made and C112 in the report for this purpose, para 112, he exceptionally included an extensive amount of detail relating to highly sensitive matters, as he put it, and he did so to fulfil his remit from the government, and he produced lots of them declassified for the very purpose of the documents that you've seen in Volume 2. And that was one of the core and essential purposes, was to open up that material, which called for some, no doubt, pretty anxious reviewing of classification. But much that was not in the public domain has now been made public. And one can be pretty confident, I respectfully submit, that as much as can be published consistently with national security needs has now been published. This is indeed, therefore, a full public account. This is not, as it was pejoratively put by my lady friends in submission, examine the width and don't feel the quality, or however he put it. This is a proper, considered, thoughtful report after a rigorous process.
Could you remind us of the reference to Volume 2 of the report, which is somewhere else?
Volume 2 is in, does my lady want where to find it? It's in Appendix 6. It's the whole of Appendix 6, effectively. It starts at MS 2208, 1887 in the hard.
Thank you.
I then briefly return to the suggestion that no one could have properly concluded that the process of review would be an adequate or effective means of getting at the truth. We respectfully agree with the courts below, see in particular on that issue Mr. Justice Stevens at 172 to 177. The fact that it was not a full-blown 2005 inquiry does not render it ineffective. And one needs to recognise that the potential additional bells and whistles, take that phrase from Lord Roger Annell, the additional bells and whistles come at a potential real price, notably in terms of time, expense, and potential for endless legal wrangling. It was effective because there was critical examination of contemporaneous documentation, likely to go a very long way in this context, particularly perhaps given the length of time that had passed. There was no indication, and there is no indication in the report, indeed quite the reverse, that persons who had relevant evidence to give were not prepared to cooperate.
Well, there is the handler.
There is the handler, but there's nothing to indicate that the
Well, he refers to medical evidence.
medical evidence.
Has that been made available?
Again, I'll have to check whether that's there, but he was evidently satisfied. There's no adverse comment in relation to that from him. I mean, if he was unhappy about that aspect of it, it's entirely predictable and indeed would have been consistent with the theme of the report for him to have said so, I respectfully submit. But there's nothing to indicate he didn't have the full gamut of documentation, everything he wanted and everything he called for, or that, subject to the point we've just been discussing.
Does he say at any point that he interviewed all the people that he wished to?
I thought that was the essence of the list that he gave.
He does, though he's got a list of 7 people he wanted to interview,
Who were dead.
but sadly deceased.
Who dead, yeah.
And
Those are
the one
paragraphs.
person who was, for medical reasons, he didn't interview.
Yeah, but he interviewed Colonel J, for example. And indeed, one needs to bear in mind in relation to the, so there's compulsion to get documents. You didn't need that because it was all in the hands of government departments and they were exemplary in their cooperation. In terms of live witnesses, as it were, you've got the medical issues relating to the handler, but everyone else, it appears that he wanted to talk to, he talked to, and could talk to after this length of time he talked to. But one does need to be a little realistic about this because it might be thought, on one view, that he was a great deal more likely to get sensible and considered cooperation from live witnesses in a process such as this than in a public inquiry. Of course, if you set up a public inquiry under the 2005 Act, as we all know, there is no guarantee that witnesses will cooperate. The dilemma is a live one. True it is that, as we saw from the Inquiries Act provisions, under Section 21, there are powers to compel witnesses if necessary, But of course, the difficulty that one always has in this sort of situation is what they do when they get there. And what they tend to do when they get there is, if they're remotely in the frame, as it were, for criminal offences, is to plead the fifth. So they plead self-incrimination, and you don't get any useful information out of them at all. And the way that that is normally dealt with in inquiries of this kind, I think it occurred in Savile and indeed some of the other ones, is that you get an Attorney General decision or indication from a law officer that nothing that they say in giving answers to the public inquiry will be used against them subsequently in evidence in a criminal process. That's how you square that circle. Of course, the difficulties of doing that in a context such as this are obvious. There would have been the very gravest issues as to whether or not anyone would have thought it appropriate or proper to give those sort of undertakings, and it may well be that the family would have had some pretty strong views about that were that to be done. But the only reason I raise those points is because there isn't, as it were, a monopoly on process. There are advantages and disadvantages in doing it in one way rather than another way. And it's a very easy thing to say, well, normally in court processes and public inquiries we cross-examine people, or the chair cross-examines them. I mean, even in public inquiries, the chair can say, I'm not going to allow families or interested persons to cross-examine, I'll do it through counsel to the inquiry, or I'll do it myself. There's no right to cross-examine in a public inquiry in any particular person, but there are advantages and disadvantages in doing it in a variety of different ways. But De Silva felt able to make the judgments that he did, and they were trenchant, having followed the process that he did. And so we do submit that it is possible entirely to have a thoroughly effective process without compulsion, if that's where my learned friend now focuses. Below he focused much more on cross-examination. Now it appears to be on compulsion. But you saw what De Silva said about compulsion. Didn't feel the lack of it in a nutshell. And his report is living proof, I respectfully submit, that you can have a thoroughly effective process without compulsion. He obviously didn't need it for documents, but nor did he need it to get to proper conclusions about the truth of the matter.
But when it comes to documents, am I right in assuming that the documents that are published in Volume 2, which are heavily redacted, were seen by Sir Desmond in unredacted form?
I think you're right in assuming that. Again, I will double check, but I'm pretty sure you're right.
Well, it would be quite an important
Yes, it will.
point.
Let me check. And I make the submission I do about effectiveness despite lack of compulsion, and indeed there are many such inquiries, some going on as we speak. You will recall, or you may not recall, because I can't remember this, I'm not sure it's reached this level quite yet, but whether it does or doesn't, there have been a whole series of difficulties in relation to Iraqi claims and investigations of alleged misconduct by British servicemen in Iraq and Afghanistan, particularly Iraq. And there were a whole series of cases, one of which is in the bundles before you. It's called Ali Zaki Musa. And in the end, what's happened in relation to those, consistently with the conclusions of the divisional court, I think it was Lord Thomas, Mr. Justice Silva, is that Sir George Newman has been appointed to conduct a series of Article 2 compliant inquiries. And he is not set up under the 2005 Act. He does not have formal powers of compulsion. So he's very much a De Silva style review. And of course, in those circumstances, and it may be that in Northern Ireland, with all the issues, the legacy issues that are going on there, it's a similar sort of example, similar sort of difficulties. Of course, the issue that was confronting the divisional court in Ali Zaki Musa with all those claims from the Iraqis was that they were confronting claims of the most serious wrongdoing by 2,000 alleged people. I say alleged because there were some issues in relating to the conduct of some of the lawyers representing them, but they were confronting a very large number of potential claims and a very large number of people who could turn up and say, I've got an arguable breach of Article 2 substantive, and or, bear in mind these investigative duties extend this far, an arguable breach of the Article 3 investigative duty, in other words, ill treatment. So some process had to be devised in the Iraqi context, and will have to be devised, no doubt, in relation to legacy claims in Northern Ireland, to deal with the sheer volume. And frankly, if the De Silva report is not enough for the purpose of Article 2 or Article 3 type satisfaction, if one gets to that and has to, even if one has to rely upon it exclusively, if that is not enough, then goodness only knows how the system would ever cope. Very briefly on the principle of compulsion, my learned friend relied upon Edwards and the United Kingdom, as you will recall, and he sought, as he did below, to rely upon the Minnesota principles. But it might be thought that the only relevant bit of the Minnesota principles where he could point to a dissonance with De Silva was in relation to compulsion, which is no doubt why he focused on that. But certainly, at least in relation to the more recent version of Minnesota that he handed up, when you get to the bit, I'm not going to invite you to go back to it, but when you get to the bit dealing with compulsion, just have a look at the footnote, because the footnote references back to Edwards and the United Kingdom. And my respectful submission is that Edwards and the United Kingdom is not authority on any view for the proposition that in order to be effective as an investigation, so as to comply with Article 2, or indeed Article 3, investigative, there needs to be the power to compel. It is simply a case on its facts in which the lack of compulsion in truth rendered the investigation in the very case ineffective. So it doesn't stand as authority for the general principle which it appeared to be wheeled out for. And if Minnesota was relying upon it, it comes with that caveat also. The second thing to bear in mind in relation to Minnesota is when and if you go back to it, and I'm going to go back to it briefly under Article 2, and if you go back to Finucane against the United Kingdom in Strasbourg, and you'll find the judgment in, I think it's the second appendix, I'll just give you the reference. It starts at MS 816, is Finucane in the United Kingdom. The key point for present purposes to note about that judgment is that in the usual way they have their section headed relevant international law, and under relevant international law between paragraphs 56 and 59 on MS 829 and 830, the European Court of Human Rights cites and relies upon the UN principles on the effective prevention and investigation of extralegal, arbitrary and summary executions, and they rely upon or cite at least, the Minnesota Protocol. And the significance, of course, of that is that when you come to the description of the principles in Finucane, they are entirely consistent with the principles that you're very familiar with about the necessary ingredients before you are able to comply with Article 2 or Article 3 investigative duties. And they've been well established over a series of cases, Jordan, Macaire, Kelly, and all of that, analysed ultimately by Lord Roger in L, as we will see. But those principles, that statement of principles, how heavily analysed in the Strasbourg and domestic case law, already takes into account Minnesota and the UN provisions. And so they don't, in truth, add anything to the Article 2 or Article 3 compliance duties. Just before turning to Article 2, so that's, as it were, the end of legitimate expectation, and under those three broad themes I've sought to analyse and pull together what we say about overriding justification.
Can I just ask you, under legitimate expectation, assuming that's the right label, where you have a promise, which is not what I would call a Cochrane promise, which is a promise made to a small group of people, which is acted on in reliance, but is a statement of policy, which is what you say this is. I think you accept that there have to be good reasons for going back on it. What test does a court apply in considering the adequacy of those reasons?
Well, you've got a choice. I don't want to
I
don't want to reopen old United policyholders' wounds, but there is a choice. The old case law, I say the older case law, all the analysis of Lord Justice laws in Nataraja, Begbie, Bat Murphy, all of those well-known cases that you analysed in United policyholders, they all place that standard on a spectrum, effectively. And the closer you get to it being an issue where one would naturally expect government to make the decisions, the closer you are, therefore, to policy, reformulating and formulating government policy.
Yes, I mean,
the harder the standard.
I was trying to get away from the spectrum analysis, and maybe this is not the case where it matters, but because it's very difficult to decide where you come on a spectrum. And on one view, I mean, where you've got the sort of the Cochrane type case, small group of people relied on, similar to contract, that's not this case. But apart from that, I mean, it would be arguable to say, well, it's rationality.
Well, that's a submission that we make in our case on the back of.
Once you get away from a rationality analysis, what is it? Proportionality? No, it's not.
Well, that was how my lord put it in United policyholders, but in the different context he was thinking about there. But I mean, ultimately, we're back into that debate.
What's the test that you say we should apply?
I say you should apply the Lord Justice Laws approach, particularly the section. I think it was in Begbie, from memory. It was that bit I took you to, where Lord Justice, as he then was, Lord Justice Lloyd Jones, cited that bit from Begbie in para 61 of Patel.
I see. Okay.
That's the approach we respectfully submit as the correct one. But it ultimately is we submit a rationality standard. But even if you choose to put the label of proportionality on it, that is a broad enough church to allow for differentiation between the Cochrane type situation and the big broad set of policy issues. So it may matter less what label one puts on it. I was about to say we don't want to go back into the debate that the Supreme Court declined to get engaged in about rationality versus proportionality in KU, if you recall that.
Well, you recall it only too well. And we foresee it may come back.
It may come back, but I mean,
ultimately... I think we said that in KU, that it would come back.
Yes, but someone's going to have to identify a case in which it all turns on that, which may be more of a challenge, because the temptation may be to say, well, rationality is a context-specific thing as well. Anyway, not going there. My submission is rationality. I wanted to finish a section before coming to Article 2 with predetermination and unlawful interference. And my submission, you won't be surprised to hear, is that the process was not a sham. That is an utterly unfounded and fanciful submission, impossible to square with the contemporaneous documents. And the courts below were absolutely right, both in their careful analysis and their conclusion on this issue. The conclusion of Mr. Justice Stevens is at 181, and his reasoning is in particular behind or in 194 to 202. But you need to bear in mind that that analysis and that reasoning sit, as it were, after his very careful analysis of the sequence of decision-making between 100 and 140. And in essence, the Court of Appeal upheld that reasoning and those conclusions. See Court of Appeal 41 to 61 and 133 to 134. It appeared to be suggested that there was some vice in the Prime Minister having been involved in this decision-making. Decision-making, of course, is for government. Sometimes acts or regulations identify a specified or particular Secretary of State, but otherwise, if there are general references, even in legislation, to Secretaries of State, then that decision-making is for any Secretary of State and or a group of ministers collectively. That's the way the Convention operates. It's entirely appropriate and lawful for this to be, given its public interest importance, given its international potential ramifications, for this to be a collective decision at the very highest levels of government, including the involvement in the decision-making process and in the decision itself of the Prime Minister. And frankly, if the Prime Minister had not been involved, and assuming that a ministerial code would be justiciable, which it probably wouldn't, there would be serious cause for complaint if he hadn't been, because the ministerial code required him to be consulted about any decisions to do with major inquiries. And that is a point that the learned judge noted at 202 of his judgment. And frankly, this involvement of the Prime Minister, if anything, operates strongly against my learned friend's case, because it illustrates the sheer weight and importance of the public interests and the political issues, and the international issues indeed, of the decision taken. Then my learned friend says, well, in truth this was predetermined and unlawful because it was simply following, it was all a stitch-up following a government policy that there would be no more open-ended and costly inquiries. But with the greatest respect to him, that submission entirely falls away once one understands what the true nature of the policy was. In other words, you don't take the single sentence at the top of that page in the letter launching this process, you take both sentences together, including specifically that the no more costly and open-ended was expressly subject to each case being looked at on its merits, and that's precisely what happened. And that was the learned judge's finding, entirely properly open to him. See paragraph 100 of his judgment. Can I turn to Article 2? And I'm going to try and do this in three parts. The engagement of the investigative obligation, first, second, if engaged or triggered, compliance, and third, even though it's a bit of a mishmash between the two, Brecknell.
Third is?
Brecknell.
Brecknell.
Brecknell in the United
Thank
Kingdom.
you, yes.
New information.
This is new stuff, isn't it?
New stuff comes to light.
Yeah.
And the first bit of this is perhaps by far the most difficult in terms of the principles to be applied, as recent case law demonstrates. I'm not going to go back over it all before my lady sighs too hard, but the court will need to read or remind themselves of Macaire, Janovich, Mogochi, and KU, and we would respectfully say KU, both Court of Appeal, if you can face it, and Supreme Court. And just very briefly to traverse that case law, and I'm not going to spend a lot of time going through it because it will be very familiar or will become very familiar, but the position in essence developed in this way. Macaire was the starting point, authorities bundle 3 tab 37 MS 4119, and it held in a unanimous decision of the House of Lords that it was a complete answer to any suggestion post-October 2000, when the Human Rights Act came into force, that the death had occurred before that date.
Well, that was because the rights contained in the Act did not operate retrospectively.
They didn't, apart from in very limited respect set out in section 22(4), but it was also based, as the subsequent case law squarely recognises, on the fact that up until the date of Macaire, the Strasbourg case law, I hope I'm fairly summarising, the Strasbourg case law had treated the substantive duty not to take life and the procedural duty as being intimately intertwined, in effect, the one being adjunct.
One parasitic on the other, yes.
Exactly so. And then one had Shelley, or in its modern incarnation after the storm of criticism, the Grand Chamber's judgment in Janovich. And those cases in Strasbourg, of course, addressed a different set of issues, albeit with analogue or echoes into our domestic system. I say a different set of issues because they were addressing the position in which a death occurs before the date on which the relevant state signs up to the European Convention.
A death or a disappearance, I think.
A death or a disappearance. So they're addressing that international issue, as it were. And that is why, on the facts of KU, there was a debate about the significance and the correctness of applying either the date on which the convention was signed up to, which was 1953, I think, as compared to the date on which the right of individual petition was afforded, which was 1966.
53 was when it came into force
Came
in
into
relation
force.
to, we signed up to it, number
But,
one.
Yeah, but one sees immediately the significance of that in relation to that debate, because you've got another 13 years if it's pushed back to the date of individual petition. But what Shelley did was in effect to say in the Strasbourg jurisprudence, it's no longer a complete answer that the death was before the critical date, because the procedural obligation is detachable. It isn't purely parasitic as a species of obligation. And given that it's detachable, it can alight, for the sake of argument, it can alight on a process that occurs after the critical date. As I say, it may well be that the court doesn't need any more to go back to Shelley, and that its better port of reference, as it were now, is the Grand Chamber's decision in Janovich, which is behind tab 49 in bundle 4, MS 4535, and it represents the European Court's current position of how those principles work. So they're principles that are designed to operate and do operate in the Strasbourg context, where the critical date is not HRA coming into force, obviously, but it is when did the state sign up, to use that neutral expression, to the convention. Of course, some Eastern European states sign up later, so it's a real live issue for them. The principles to be derived from Janovich, we respectfully submit, can be briefly stated or summarised. Firstly, the principal purpose of the investigative obligations they emphasise is to identify and punish, if appropriate, those responsible for unlawful death, not to establish historical truth. Janovich 143.
I suppose it's not just to establish historical truth, because establishing historical truth would be part of identifying perpetrators and bringing them to justice.
Of course.
But I think the distinction is
the
one
mere.
that is simply
That's my latest judgment in
historical.
KU, it's the mere.
Yeah.
But they also make clear in that same paragraph, secondly, that it isn't a continuing obligation, it isn't just a mere continuing obligation. They reinforce and repeat the Brecknell principle. They do that in 144. The obligation to investigate may be revived in circumstances where otherwise it's applicable, but it may be revived by, as they put it, plausible, credible allegation, piece of evidence or item of information which comes to light and which is relevant to the identification and eventual prosecution or punishment of those responsible. 144 of Janovich. But there is a genuine question as to whether or not, even if there's a revival, where the death occurs before the critical date, is that enough? Or has it also got to pass the genuine connection tests and the convention values tests? It's an issue which is, as it were, thrown up by the final two sentences of 144 of Janovich. But if one's looking to see the link back to a pre-critical date death, one starts with genuine connection, as they put it, Janovich 147. And there are two criteria, and they are, in summary, lapse of time, and the principle is that it's got to be reasonably short, and, as they put it at 146, should not exceed 10 years. And they do go out of their way in the final sentence of 146 to set out the nature of the exception to that. In other words, if you're going to go longer, namely convention values, the second option, being in play. And also note that this is a separate condition, separate to investigatory steps, which I'm going to come to, and has got to be satisfied as such. So although it may not be entirely absolute in terms of the 10-year rule, and one can find some cases in which death was, say, 13 years post-ratification. Mladenovic and Serbia is that example, the 13-year case. Authorities for tab 52. But bear in mind that was a case decided in 2012 before Janovich. And there is a real virtue, I respectfully submit, in having something which, even if it is not an entirely unporous line, is nevertheless a pretty serious line. And the reason for that is obvious, and it was the one mentioned by Lord Neuberger in KU, which is the need to provide legal certainty. So the first of the two criteria is lapse of time, and the second is investigatory steps, 147. And the paragraph in my Lord Kerr's judgment in Magochi was, I respectfully submit in this respect, that my friend took you to, I can't remember the number, but the one he took, the passage in my Lord's judgment in Magochi, was effectively trying to summarise, if I've read it correctly, this element. Much of the investigation must have taken place, or ought to have taken place, after the critical date, is the way it's put. But I do submit that 1 and 2, that's lapse of time and investigatory steps, are cumulative. If you don't meet either, there will be no investigative obligation. And for that purpose, and that is clear that they are cumulative, see Janovich 148, which makes that expressly and obviously clear. And the second of the two options is convention values. Just before leaving.
So that's different from genuine connection.
It is, I respectfully submit. I should have made the point.
Well, would you like to return to that after the short adjournment?
Of course. Sorry.
In case it requires a degree of expansion. It may not.
I'm not going to be very long.
Very well. Well, we'll adjourn now and return at 2.